Understanding the Constitution Review Committee reports. This is part 2. Even though this will be the 3rd week that we are seeking to give you education about the summary of the recommendations. That's the report that was submitted to the President by the Professor H. Kwesi Prempeh-led committee. Last week, we're fortunate to have Dr. Jokoto Godwin helping us to understand some of the recommendations that are not that popular. Today, we'll continue and conclude this project of bringing you the portions, mostly those that are not popular, but very important recommendations to change the architecture of the Constitution and give Ghana a democracy that works. I'm Samson Ladia Nyanini. This is the law. It's your legal light. It is your health law. We'll be right back. Welcome back. And my guest is Dr. Reina Kumpergia. He is Secretary and member of the Constitution Review Committee 2025, and he's founding partner, Partners and Associates law firm, helping us to continue with the education that we have been giving. Doc, thank you very much for making time to join us.
Thank you, Samson. Thank you so much.
Great. And before we get into what we are going to do, the question that I have asked almost any member of the Constitution Review Committee, from the chairperson that I had the privilege of interviewing right after the report was presented, together with Madame Charlotte Osei, former boss of the Electoral Commission and also former boss of the NCCE, has been, and of course your own friend and colleague Godwin Jokoto, has been what the experience has been for you, being a member and going through the country, interacting with people about what is on their hearts for constitution reform. What has the experience been like?
Thank you. Personally, sometimes you think you know your country, but when you interact with it in a certain context, especially in a context that you want to understand what the people want in respect of the democracy that we are running, then it throws you out of your knowledge comfort. We all go to Kumasi, we've been to Upper West, we've been to Volta region and all of that. But you don't go there asking them constitutional questions. You don't go there asking them what's the architecture of the constitutional design that we want to now have going forward and how can we improve as a collective. So that's been eye-opening in terms of what the people, views and opinions are. And we're stuck, not just me. I think that once in a while, you engage with other committee members. We're stuck by the excitement and the zeal and the level of knowledge. The level of knowledge of our people, of our governance systems and our constitution was mind-boggling. And this cuts across the entire country. It wasn't just Greater Accra or some other urban area. In fact, it was the entire country. And that was a bit surprising, but we also got to know other differences as we travel around. So it was an eye-opening.
For the chairperson, it was a revelation. Yeah. The opportunity to see places he thought he knew, but he didn't know. And together with Charlotte, and also seeing some of the deprivation, bad roads.
So the bad roads, I have to mention.
So will what you guys have proposed in the review solve the problems of the bad roads?
Bad roads, what immediately comes to my Samson is the roads between, when traveling from Damango to Upper West. That was, I think it's one of the most terrible roads. And I've seen terrible roads. My own constituency, Bongo, You know, there are, apart from the road that leads you from the capital to the state, and recently another one they are doing. I have a fair view of what bad routes are, especially the border town and all of that. But that particular route was, you know, it was hectic, it was frustrating, and it brings to fore what we're doing, especially in respect of local development, a local governance system,
right,
and how they respond to local issues. But some of the projects were just such scale and magnitude that they were beyond local issues in terms of their resource base and their competency to carry out those projects.
Does all these experiences in any way inform the choice of the theme for your work? The Professor Albert Fiajo, Professor Raymond Atuguba, Secretary to the Albert Fiajo Constitution Review Commission work, they said from a political to a developmental, you know, constitution. Yeah. And you say what?
Well, so our theme is from, I think it's similar.
Right.
Because in fact, why it is similar, first of all, is because we realized that because the Fiajo report was released in 2011.
Right.
Isn't it? So from 2011 till 2025, January, it's easy to see that the development that would have been envisaged under that report has not occurred. If anything at all, I think some of the scenarios have worsened. And so we wanted to maintain the development aspect of it and to say that, look, there's still a yearning for development.
Right.
The citizens don't want to be participants in the democratic process by merely voting. They now want to be stakeholders. But this process has to be quicker, and it has to be in a hurry. Right. That is why we introduced the concept of revolutionizing the process of constitutional development.
Right. So you say this what your committee says about your theme. The transforming Ghana from electoral democracy to developmental democracy. And you say that transforming Ghana from electoral democracy to developmental democracy represents the culmination of this extensive national dialogue and reflects the deep aspirations of Ghanaians for a constitution that moves beyond the ritual of elections to deliver tangible improvement in their quality of life and material well-being.
Very much so. And I think that, you know, we couldn't have put it any better than that. The citizens want to, between the electoral cycles, so 2011 or 2012, 2016, 2016, 2020, 2020, 2024, between each election, governance should actually happen. So you have an election, you choose a president, he forms a government. We need to move from the process of the election and transition into actually governing and delivering goods and services for our people.
Right.
And so this ritual is in reference to the fact that every election year you have a general election. Then so what?
Yeah.
I haven't delivered a president. And that has been very seamless.
Right.
I've heard people argue that, oh, the Constitution has done well, it has delivered. What has it delivered? And we can concede that it has delivered elections. Yeah, despite the chaos and the tensions and everything.
Incrementally, our lives are not that better.
It's not better, and there's no direct correlation between the voting cycle and the aspirations and expectations of our Ghanaians,
right,
and what actually happens on the ground in terms of water system, in terms of local development, in terms of other development.
Thank you very much. So for those of you who may not have been aware, the committee did a number of things, and like the very first committee, 2010-2011, Professor Albert Fiajo, they engaged with the Ghanaian people. They brought us a document of 1,000 pages. And then in 2024, we had the Claraberry Committee set up by the Parliamentary Affairs Minister, Osei Mensah-Bonsu. They also gave us, I think that was almost 400 or is it 248 something pages report. I referenced it in the very first episode. I will look at it again and be very precise with what we had. Now, what did this committee do? The committee received 735 electronic submissions by way of email and its website, as well as 50 manual submissions at its secretariat, making a total of 785 written submissions. Then the committee organized 10 thematic stakeholder engagements, benefiting from the expertise and insights of over 500 experts and practitioners on the various thematic clusters.
Including
the committee, privileged to have been there. Yeah. The committee also held 17 stakeholder engagements with identifiable groups ranging from members of parliament to the media, from the business community to academia and the youth. Through those engagements, the committee benefited from and reached out to over 21,000 people, which includes 21,000 young people who tuned in to the committee's X Spaces engagement. The committee also engaged with 11 eminent persons who have worked with the Constitution over the past 32 years, including the sitting president, John Dramani Mahama, former president John Ejekun Kufuor, former president Nana Addo Dankwa Akufo-Addo, and the current speaker Alban Bagwe. The committee traveled around the country and conducted zonal public engagement with citizens. In all, 10 zonal engagements were organized in the capitals of the 10 old regions. These zonal public engagements attracted the active participation of a wide cross-section of society, from youth, persons with disabilities, market women, chiefs, queen mothers, Tindana, NCCE, and other state agencies, the security services, driver associations, students, among others. A total of 2,436 Ghanaians participated in this zonal engagement. This is the result of that engagement. Summary of the recommendations. We are yet to see the full report and the full details of the recommendations. So today, as you take your turn, what are these portions of the recommendations that excite you, but have not excited the media to give it as much attention as, extend the term of the president, to 5 years from 4, extend the minimum qualification age from 40, reduce it from 40 to 30. Yeah.
Thank you. So, like you rightly said, I think that what we sought to do as a committee, and that process was very extensive, by the way, and the recommendations are a culmination of everything that we heard and saw and felt. Okay, so these are the recommendations, and they reflect exactly the processes that we went through. Like you rightly said, there are very critical reform areas and recommendations that we have made.
Help us. We want to.
Unfortunately, the media do not cover them. Yeah. For instance, the committee is recommending some reform in respect of Article 286 of the Constitution, 1992, in respect of declaration of assets. Okay. So if you look at Article 286, for instance, which is under Chapter 24 of our Constitution, there's a requirement under Article 286 that a person who holds a public office, and then it is referenced to Clause 5 of the Constitution, will submit or shall submit to the Attorney General a written declaration.
The Auditor General.
The Auditor General. So the holder of the public office shall submit a written declaration to the Auditor General, right, of all property or assets owned by or liabilities owned by him, whether directly or indirectly. So in addition to this, and something what I'm trying to do is to give us the regime as it is now, right? Then we can identify the gap that we saw or that our attention was drawn to, and then the proposal that we are making in order that we can fill that gap. You have to read Article 286 together with the Public Office Holders, into brackets, Declaration of Assets and Disqualification Act, 1998, Act 550. Okay. Most of the provisions of this act mirror the provisions of the Constitution under 286, except that under sections Part 1, particularly Section 3, it requires public officers to make the declaration under this act and then to obtain the funds from the Auditor General. And that the declaration shall be made by the public officer before taking office. That is one. At the end of every 4 years, which is the tenure of office of the presidency. And then at the end of the term of his office, which can terminate earlier, and shall in any event be submitted not later than 6 months of the occurrence of any of the events specified in the subsection. Now, you see that there's a little variation between the Act and then the Constitution in terms of when the declaration can be made. The Act extends it to 6 months. Now, but the crucial point...
Which is actually unconstitutional.
Which is, now, there was a public interest body, ASEPA, that went to the Supreme Court, challenging the constitutionality.
The Occupy Ghana had started a process and actually got the Attorney General, then Gloria Kufu, to concede in writing that extension by the Act is unconstitutional.
Okay.
Yes.
Yesterday, I was looking at the conclusion of the Supreme Court ruling, ASEPA versus Attorney General. I don't know, I'll be interested in that.
Okay.
But these are the critical things. Beside the declaration, there's nothing else. Okay. It would even appear, if you look at the Act, for instance, it will appear that the Act places the declarant the responsibility to so make the declaration. But we are going beyond that, because this declaration, whether the matters that are declared are true or not true, it is not captured. Whether the financial position of the declarant is actually true and reflects what is on the ground, it is not stated. There's no independent verification process to determine that the assets that have been declared are complete for identification purposes, that they actually belong to him or not belong to him. And you're a lawyer, you know that once we're dealing with property, these properties can be joint properties.
Right.
They can be property held in common with family members and all of that.
Right.
So what we are proposing is this, that to ensure that the declarations capture the true financial position, because that is important. If you look at the entire asset declaration regime, there's a presumption, and that presumption will be established by the declaration at the entry and then declaration at the exit, right? So we have to make your financial assessment of your financial position when you are entering into office and when you are exiting office.
That's right.
Then any difference should be attributed to income that you could reasonably have been said to have obtained from your office.
Income, inheritance, loans, a few other things.
Gifts.
Gifts.
And all of that. So now, so we can put that in practice. When there are excesses, then the burden is on you to explain why there are excesses. Now, so the recommendation is to ensure that we capture and have a system that is resilient and more transparent. Okay? So to ensure that we capture, number one, the true financial position of the office holder, we should require the declarant of the assets or his liabilities, including members of the immediate household, specifically the spouse and unmarried children. This is a major difference. Article 286 hints at that. It says that directly or indirectly. So this indirect could be the immediate family members.
Right.
We are saying that specifically the spouse and unmarried children. I mean, you know that in terms of concealment, people use relate.
Yeah, they will They will steal and...
Yeah, exactly. I mean, exactly. When there are resources obtained through untoward or through corrupt means or practices, various ways that they want to hide them, register them in the name of your wife or in the name of your child and all of that. We want to capture all of that. Indeed, within the banking circle, I think they call that politically exposed persons.
Yes.
So the politically exposed person, in our understanding, yes, should go beyond the declarant to his immediate family members.
Right.
So that's the first thing. The second thing that you'd see is that the declaration form should actually be unsealed. You should open them. Okay. Otherwise, if you keep the declarations of the declarant sealed, no one knows what it is. No one knows whether it is complete, incomplete, whether the facts are true or not true. You have no ways of knowing.
And so auditors general have made this complaint before.
Over and over.
There was Domilovo who said, even though he doesn't see whatever it is, he insists that, you know, if you are bringing a document to me, you can't just put it in an envelope, hand it to me and say, I cannot open it. So I will open and see what it is. Precisely. So now you are by constitution requiring that when they declare their assets, write them on a piece of paper, put it in an envelope.
Thank you.
Or the form, there's actually a form. Put it in an envelope and hand it to the Auditor General. The Auditor General is entitled to open it and see what is in there.
Thank you.
What, beyond that, what?
So beyond that, so we can immediately see, so verification then follows.
Good.
You know, because once you open, the contents will be known. You know, whether you own a property at East Legon, whether you have a house in Zoko or wherever it is, we will know that this is a list of your houses, a list of your cars. If you have companies, whether those companies by shares or the shareholding and all of that. Now, the verification is to ensure that, and there's a period within which the Auditor General will verify by the recommendation. And this period is 90 days.
Within 90 days.
Within 90 days.
Receiving the declaration.
Yes.
The Auditor General must verify the truth of the matters contained in the declaration.
Yes. And the Constitution should impose a duty upon the declarant to cooperate fully with the verification process.
Right.
You know, and then it should authorize the Auditor General to request the assistance of the public and relevant public agencies. Because this verification may not stop with the Attorney General. He has no way of knowing the veracity of those facts. So if we say...
That's actually going to be a lot of work.
And which is why I'm requesting that henceforth, actually, if this recommendation is carried through, it will be in the interest of every public office holder to consult a lawyer or to engage a lawyer in this verification process or declaration process. Because whether a property is, and we're dealing with self-acquired properties here. What if the properties are jointly acquired? What if they are they're in trust? What if these properties are, you know, held in common?
I'm looking at the burden of the Auditor General here in Accra receiving your, you know, asset declaration.
Yes.
And then within 90 days, they are supposed to go and verify. If you say you have a house in Gambibgo, they have to go and confirm that, in fact, there is a house there. And not because you are coming to office as a minister, you have put in on the paper that you have a house there, so that when you get into office, within 6 months, you build a house. So
precisely.
They will need personnel.
I get what you are getting at, Samson, and it's onerous. But democracy comes with a cost. I think that there's no single subject matter that occupies the attention of the Republic at the end of every government tenure. It's so huge. And the figures that are being mentioned as being proceeds or proceeds that can directly be linked to corruption or corruption-related activity are so huge and such that what efforts are required to ensure that we recover this money.
That's right.
But this process is not recovery. This process is actually to make sure that you don't wait till the horse has bolted, then you want to close the stable. Yeah, you take, it's more preventive.
Right.
So it's good. It also puts the declarant on notice. Okay, I think this process is to advertise to every someone seeking political office that you have to submit yourself to this process, and actually you have to discuss with your family as well, because your wife and your children, unmarried children, are going to be subject of...
At the end, the Auditor General is supposed within 15 days after the verification process to issue a verification audit report about this thing that has been done.
Yes.
And a copy of this report is to be submitted to the President and to the Ethics and Anti-Corruption Commission for any further action in accordance with law.
Yes.
This is interesting.
It's quite interesting. And just before that, so when we refer to the public institutions, so what comes to mind will be the Registrar General. If you say you have a company and you have a number of shares in it, then that company, the Registrar General's office would be required to, a lands commission, for instance. If you have a land and say you have acquired, you've done, going through the due process, you have acquired a land, we'll be interested to know that this land certificate, does it tally? Are you actually a registered holder of the land and the lands commission? So these institutions...
So this is number one, so that we're able to cover quite a bit for our audience.
Okay, so...
Number one. The number one is that there's a recommendation to tighten and improve the asset declaration regime in a manner that helps us fight corruption or prevent it.
Yes.
If you read the Auditor General's reports, yearly annual report, we have issues of theft, lack of accounting, misuse of public resources, and as you may have heard me say over a period, in the last 5 years alone, almost 80 billion Ghana cedis has been lost to misuse and thefts within our public offices. And you also know the report that tells us that annually this country loses over $3 billion to corruption. Now we understand that's gone to about $5 billion to corruption.
Yes.
They are saying that this recommendation, and as you can see, will help us to tighten the loopholes and help us to keep our money for our development. You have heard the anti-corruption CSOs campaign for a very long time that the asset declaration, there ought to be publication of it and there ought to be verification of it. They say there will be verification. As for publication, you haven't recommended that. Let's go to your next issue.
So our next issue, that's the elephant in the room, concerns the Attorney General.
All right.
My big brother's office. So I say it's a big issue because and that is tied to this subject. So you can actually decouple them because once you bring in Article 88 powers of the Attorney General, as well as other allied institutions like the OSP now and the Shirach. And so I'm going to discuss this topic together with the Attorney General, because we're recommending a number of things. Now, so as a start point, the Constitution vests power on the Attorney General, under Article 88 of the Constitution, to initiate criminal processes and to terminate same, using his own discretion. Okay. We're recommending a number of things. The prosecutorial exclusivity that resides in the AG will be hived, will be taken away. But only a part of it.
Right.
The part of it that is taken away concerns corruption and corruption-related offenses.
Right.
Now, so the question that arises naturally is then who then takes over this mandate to prosecute also exclusively corruption and corruption-related matters? Who takes this mandate? Right. That mandate, as it is now, is partly exercised by the Shirach Commission in terms of investigations.
That's right.
Commission on Human Rights and Administrative Justice.
But not prosecution.
But not prosecutions. Yeah. But fully exercised by the Office of the Special Prosecutor.
Iyoko used to have a bit of it.
A bit of it.
And we took it away from them in 2019.
Exactly.
Okay.
But the exercise of that power by the OSP is not exclusive, insofar as even the OSP Act itself makes reference to the Constitution, because the AG, insofar as Article 88 is concerned, is still the one that determines whether or not a matter is prosecuted or not prosecuted and all of those things. So we are proposing that we set up an anti-corruption and ethics commission. Anti-corruption and ethics commission, because the matters are not necessarily always corruption. They also contain some ethical issues. That's why even the Constitution itself, if you look at the chapter that deals with these declarations, it is headed Code of Conduct for Public Officers.
That's right.
So we are mirroring this and making sure that we are merging them to ensure that we give this. So this body, this Anti-Corruption and Ethics Commission, will be a constitutional body that has exclusive jurisdiction to prosecute offenses related to corruption.
The Attorney General will no longer have that power.
No, because I will soon tell you why that is so. Because the Attorney General has too many other things that it can do. In fact, its table and its cap is already full. And it can do so without having to, so there shouldn't be any problem.
All right.
Now, another thing will happen, and that is Shiraj. Shiraj investigative powers under Article, I think, 218C or so, or E, will be taken away and given to this Anti-Corruption and Ethics Commission.
All right.
The OSP then will become functus, because then all of his functions, as it currently is mandated to perform, will be housed, we will merge with the Office of the Special Prosecutor. This is the regime that we're trying to create. We're doing so because I was just looking at the budget statement, that is the 2025 budget statement.
Right.
That was read. If you look at paragraph 217, was related to this. I want to give a certain context in terms of statistics, right? The office received, and that is at the Attorney General's office,
right.
2025 budget. The office received 2,511 dockets, initiated prosecutions in the various courts across the country, and dealt with 2,440 motions, appeals, petitions, extraditions, and mutual legal assistance. The office resolved 125 petitions, dealt with 2 extraditions, and provided 72 mutual legal assistance, among others. If you look at page 718 of the budget statement I just referred to, Mr. Speaker, in 2025, the office envisages receiving 1,900 criminal cases from the various investigative bodies, that includes Shiraj and other institutions, CID. It also anticipates proffering advice relating to 500 criminal cases to be received from the police. Now, all of these cases are not necessarily corruption or corruption-related cases. And you are aware as a practitioner yourself, the delay that we have in our courts. In fact, there's a case that I'm doing, if I have to personalize this a little bit, that I've been doing for 5 years now. It's truncated, or it's in abeyance, or it is, it's at a stage that you do not have a clear understanding why, except that the office is not
present. Was it in 2014 or 2016? The Supreme Court concluded a case.
Yes.
That case had done in excess of 40 years. And it was a matter concerning a small family property. Small family property. 40 years. Judges had died, and some had taken over that case.
The case moving.
And Chief Justice Georgina Wood remarked that that was a parody of justice.
40 years. There are some of them that are in the courts. I mean, you have personal knowledge of this, so I'm sure you can relate. 10 years, 5 years, 4 years, and all of that. We also know that that is one of it. The office also has, the AG's office also has responsibility for representing government in civil cases. In the budget statement under reference, it represented the state in 999, that's nearly 1,000 civil cases brought against the state in the various courts. This load of work. This is load of work. This is so much work. So resources can be directed at resolving these matters. If you look at the MMDAs, across the country, over 270 MMDAs, that the office received 81 agreements, contracts, 51 memorandum of understandings for MDAs and MMDAs to ensure value for money. It means that it is advising.
The Attorney General is lawyer for government.
For government.
Lawyer for all these MMDAs.
And government entities.
Right.
Everything. And that is so much. One MMDA can bring so much litigation that will require the attention and resources of that.
Even beyond litigation, all the transactions they are involved in,
agreements,
advice.
All of that is the AG.
So you're actually saving the AG.
Precisely. And making the AG more effective. Now, if you look at this budget, they were complaining of offices and other things like that. We can equip all of these offices and ensure that their mandate is exercised effectively.
Okay. So the Attorney General under Article 88 has the general and exclusive power to initiate prosecutions on behalf of the Republic of Ghana and to terminate same, as Dr. Rena Akuperegia had just said. But this general power gives it too much workload, and some of it can be, it can get a little reprieve. So they are yanking off the power to prosecute corruption and corruption-related offenses. That's alone. To give to another institution to be established under the Constitution. Call it the OSP, but it is not OSP. Yeah. It is the Anti-Corruption and Ethics Commission. And this commission will now take on corruption and corruption-related matters. Great.
Now, if I just may conclude that, so Shiraj will no longer have a mandate in investigating corruption and corruption-related activities, and all the complaints that come with it, right? Because there are abuses of human rights across our country. There are, if you look at even the same, if you look at
so it should concentrate on human rights issues.
And it's the reason why we have a whole chapter of Chapter 5 on human rights.
All right.
It's important to the country that in the architecture that we're providing into the Constitution, we have provided a whole chapter on human rights. Apart from the High Court, Shiraj is the other, big institution that will ensure that there's fairness, there's transparency in respect of
human rights and administrative justice.
Let it concentrate and give us results.
Investigations. All right. Thank you very much, Dr. Rena Akuperegia. He's Secretary to the Constitution Review Committee 2025, and he's a member also, and also a lawyer in practice with partners and associates. Now, let's get to your third issue. Remember, what we have been doing on this series is to look at the issues that we have ourselves conceded that the media has not paid attention to, and therefore you do not have the opportunity to know about these important recommendations in the report. Those are the matters we are looking at. Yes, so where next?
So the third one, I think we've already covered it, so I'll just go to the fourth one. The third one is this is a new article, okay, to provide for the establishment of an anti-corruption and ethics commission. I think I've just dealt with this, so there's no... So two things are critical there. Exclusivity in terms of prosecution of criminal offenses, as well as
corruption
independence,
okay,
corruption-related offenses. The other recommendation we are making is to, in respect of the nolle prosequi, right, which is the discretion of the Attorney General to discontinue a matter that it has commenced in our courts, criminal matter that has commenced in our
without giving reasons.
Without giving reasons. Our recommendation is that because corruption-related matters are such public interest matters, they're driven by public sentiments and the need for public to actually know why you would commence a matter, it's only by leave of court that the Attorney General may discontinue a matter that it has commenced prosecution, and that it cannot do so without leave of court. That's a
for the Attorney General.
For the Attorney General. Okay. Now that we are taking it, so that provision will apply to anybody or any institution. So whether you are the Anti-Corruption Ethics Commission or the AG.
Because presently, it is the Attorney General that has the discretion to go to court and terminate a case and say, I'm not interested. Like, we have heard about the Opuni line of cases and others. Then he does that, and he's not under obligation to explain to anybody and give a reason to the court or anybody.
Precisely.
But this Attorney General says, regardless of that, I want to explain.
Yes.
And he's been explaining.
He did so. I think you have to commend him for that.
But for the OSP, for the corruption and corruption-related offenses, the OSP law requires and mandates the special prosecutor to explain, give reasons why it is discontinuing. You are saying that now, if this recommendation is implemented, anybody exercising prosecutorial power, if they want to discontinue a case,
must seek leave of court.
They must seek leave of the court.
Which means you go by motion, not so.
Yes.
And justify why you want to discontinue the matter. That's part of the recommendation.
simply put, you are mandating them or obligating them to give reasons.
To give that reason that they voluntarily have volunteered to the public, they should send it to court for judicial discretion to be exercised on the matter, whether it should continue or not.
So that a judge will be entitled to say, you want to terminate this case. I disagree, you will not terminate it.
Or the basis for your reasons or your justification for discontinuing is not properly laid, or has no foundation, or is not in the public interest. And judicial discretion will now determine whether or not the discontinuance or the
I'm doing a matter.
Yes.
I don't want to continue anymore. I say, I don't want to go on.
Yes.
Then a judge tells me, you must go on.
Yes.
Can you imagine the attitude to which I will use to do the case?
Yeah, but that's a public interest
I'll
matter.
score an own goal.
No, you can't do so. It's a public, it's a public interest matter.
All right.
You're prosecuting, because all prosecutions are initiated, even though the mandate is with the prosecutor authority. It's in the name of the people.
That's right.
Okay, it's on behalf of the people.
Right.
Right. So if you are exercising that authority in the name and for on behalf of the people, then it's in their interest.
Right.
So if the matter is a matter for the public interest, and that it would eventually inure to our benefit, then the criteria is not longer whether you have resources, whether you are predisposed to doing it or not doing it, or whether. But of course, if you exercise poor judgment and professional judgment on the matter, that are also channels by which we can.
Yeah, but again, that was just commenting, just because
yes.
You, the prosecutor doing the case, remember that there's also a judge.
Thank you. And
the judge can take part in the case to a certain extent. Yeah. So if you are doing some wrong things, the judge can control. In the end, it is the judge that will determine whether somebody is guilty or not guilty.
Thank you.
So when the judge has to ask questions, they will ask the right questions. If you avoid asking the right question to let somebody go, let somebody off. Yes. All right.
So quickly
on the law, this is your legal light, it is your help law, and we are engaging the Secretary to the Constitution Review Committee 2025, who is also a member of the committee, Dr. Reina Akumperga. Next, that should be our 5th issue.
So there's something about public officers, and there's this annual. I'm trying to lay a foundation for this recommendation. This annual perception of interference, and politicization of the public office, right? So especially when it's a change of office, your position immediately becomes untenable, or becomes subject to dismissal or some other transfer, which is untoward, and to create an environment that you may not even be willing or able to continue. So we are proposing that the protection of public office, we need to protect them from such activities by politicians, okay? But we shall require that whilst we are protecting you because you're a public officer, that your position is not determined just by the whims and caprices of politicians. We require that you should be non-partisan. So it's a two-pronged solution that we're trying to provide here. That number one, the committee recommends an amendment to Article 191 to provide that the Public Services Commission shall make regulations by constitutional instrument to elaborate on protections provided to members of the public services under this provision, and provide administrative procedures and processes, including time limits for resolving complaints or grievances with the right of recourse to shiraj. Now, if you look at Article, I just want to reference it briefly, 191 of the Constitution, you will see that a member of the public services, this is what it provides, it's headed Protection of Public Officers. A member of the public services shall not be victimized or discriminated against for having discharged his duties faithfully in accordance with the Constitution, or dismissed or removed from office, or reduced in rank, or otherwise punished without just cause. So this provision it doesn't go further. It doesn't say how it should be done. It doesn't.
So now there's going to be a constitutional instrument to elaborate on
precisely.
Right.
And constitutional, that will give oxygen to the process and making sure that they're protected. But we make a further recommendation that therefore we require you to be non-partisan. Okay. it is required that the committee now recommends that an amendment to the appropriate section of the clause of the Chapter 14 to provide that no member of the public services shall participate in active party politics or manifest or demonstrate open partisanship or partisan affiliation while employed in the public services.
Looking at our time now, I will suggest that you go to issue 6, appointment of CEOs and management of SOEs. SOEs.
Right.
And if you can run through quick so we can capture sufficient number of these areas before time catches up with us.
Very well. Now, what I need to lay some background. Something, in 1993, a certain piece of legislation was passed. That was the Statutory Corporations Introduction Conversion to Companies Act, 1993, Act 461. And where the finance minister with the State Enterprises Commission at the time, conferred. So there were two things that happened concurrently. You converted public corporations to companies under the Companies Act. So as if they were set up and became companies so properly so-called by statutory operation of the Companies Act. Right. Now, assets, liabilities, obligations, and rights that existed in those former corporations were transferred to the new companies. And that included, if you look at the list, the schedule to this particular Statutory Incorporations Act 461, it includes the ECG, Cocoa Board, and so many of them. That is the history that we have had in terms of what is the mandate and the expectations and the governance system that should prevail in this state
companies.
In terms of the companies. So that's it. So if that understanding is right, what it means is that they should operate on the commercial basis with management and CEOs that have the expertise, that have the competencies, that have the experience, and that are fit for purpose.
Right.
To ensure that they can give value for money.
On the back of that, you say that the committee recommends the inclusion of provisions in Chapter 14 of the Constitution to provide that, 1, no Minister of State, Deputy Minister, or Member of Parliament shall be appointed to serve on the governing board or management of a state-owned enterprise or state-controlled joint venture. Conflict of interest.
Conflict of interest.
Public CSOs have been complaining about for a while now.
Right.
Now has been provided for. The appointment to the governing boards
of state-owned enterprises
shall be made on the basis of demonstrated competence, professional experience, integrity, and relevant expertise, and political affiliation and partisan consideration shall not be a determining factor in such appointment.
Yes.
So does it exclude you if you are politically, tainted?
Am I politically tainted?
I'm asking, does it exclude any person? I'm not talking about you.
Yes, as a person.
Does it exclude a person who is politically tainted from getting on the board?
Yes. So like I prefaced the conversation, is to get people with competencies. Of course, you can be politically tainted or politically exposed, yet you have the requisite expertise.
Okay.
But we want people, there are a lot of Ghanaians that are not in active politics, but that have the requisite experience and competence to run these institutions.
Right. The minimum qualification of CEOs and management of these, you say that the committee recommends that the Constitution be amended to provide that no Minister of State, Deputy Minister, Member of Parliament, or candidate for elective public office shall be appointed to serve on the governing board or in the management of the state-owned enterprises. Is that this same thing I read a while ago?
That's exactly the same.
Governing authority shall prescribe minimum qualifications for appointment to the governing boards and senior management positions of these organizations. I think we can move on and go to the establishment of an independent devolution commission. It's a place of interest. If you can deal with that quickly for us, because our time is almost up.
Okay. So two things to say about and that's about local governance. Now, we have had a proliferation of a number of districts. In fact, 261 now. Okay. We have moved the municipalities from 4 over a short period of time to 70. We have moved regions, okay? Previously, we had 50 regions. For over 50 years, for over 50 years, we had 10 regions. But within a short period, between 2018 and 2019, we created 6 more regions without any tangible results and all of that. What we have noticed and the experiences we have gathered from this process is, one, that most of the districts are non-viable. They're not economically viable. Now, they are not only economically viable, they don't have the manpower, the competencies to generate internally. If we were to ask most of them to use the IGFs to pay their own workers and just exist as a shell company without creating profit, most of them will collapse. Now, part of this is because of the political pressures that are brought to bear in the creation of districts. For political reasons rather than viability. Right. So this is why we are recommending certain changes, certain reforms in terms of election of the MMDCs, curtailing the number of this district. And I know we don't have time, but let me say this. When a Local Government Act was passed 2013, another one in 2016, those provisions have really not been followed by politicians. The population threshold was 70,000 at the time, but they left the percentage that calculated and determined the population threshold and used the raw figure and applied in every other situation, even up to now. And that's the reason why you have most of these districts.
And there's this popular demand that has been a long-standing demand that you have now, endorsed.
Okay.
The committee recommends that the election of DCEs,
that's 9,
whether directly or indirectly, shall proceed on a non-partisan basis.
Yes.
The CDD did surveys that show that almost 80% of Ghanaians
prefer
it to be non-partisan.
We
were going to do that in 2019?
19, yes.
Yeah, we were going to attempt to do that. Yes. And then before we realized, it was being changed to partisanship.
Yes.
And there was a campaign, and I don't know if I'm proud about it, which I led, that led to the stoppage of it. So, shall proceed on a non-partisan basis. The committee notes that while the party affiliation of assembly members elected on a non-partisan basis are often widely known, a significant majority of Ghanaians in survey after survey continue to support local government elections conducted on a non-partisan basis. Local communities defend the preference for non-partisan local elections on the grounds that they create a less tense electoral atmosphere, as well as less costly campaigns than elections held on a partisan basis. The committee also reasons that electing DCEs on a partisan basis is likely to, quote, nationalize what should be a local community decision or affair, as national parties get drawn into the local elections. Moreover, as local government elections are most likely to turn on local development issues, programs and projects, they are unlikely to invite the sort of major policy differences and contestation that drive national partisan elections.
So in short, we don't want the MMD elections to mirror all the problems and the tensions and the costs, not just financial, human, and everything that's associated with elections now. You don't want to transport that into the local system.
And you are creating term limits for the DCs, right?
Yes, 5 years, so that, because they were also proposing 5 years for the president.
5 years, regardless of whether they occur consecutively or non-consecutively.
Yes.
Thank you so very much.
That would be a proposal.
This has been enriching. And I discovered that for almost every point, there is a certain background you want to bring to it.
That's so.
Thank you so very much, Dr. Reina Akumpergia. He's taking us through a number of some of the recommendations that are not popular, but we must also help to popularize them so we know that there are important recommendations that have been made. The Attorney General is going to lose the power to prosecute corruption cases. Of course, this is acceding to and listening to our demands over the years that the Attorney General they are not able to prosecute their own, and so you need some other, body to be able to do that.
Devolution Commission.
Yes. Dr. Reina Akumperegia is Secretary and member of the Constitution Review Committee 2025, and he's founding Partners and Associates Law Firm. What will be your final word in 30 seconds?
This has been good. I'm sure that we will have this conversation again. We're inviting the public to show interest, to be interested in these things that we're doing. Ultimately, the committee has done its work. It will take political will, which I have no doubt that exists, to carry through this. And that when it comes to the turn of the public to participate by campaigning and educating themselves on the matters, they should do so we can all have a successful process in giving ourselves the constitution that we desire and deserve.
Thank you very much. Once again, we want a developmental constitution rather than a political one or a partisan one, or one that is just for purposes of elections every 4 years. I'm Samson Ladi Anyanini. This has been The Law. It's your legal light. It is your help law. We hope we have helped you.